You guys, Karen Reed and her team are now on the offense, and they truly are pulling no punches. Today, we're going to go over the complaint that was filed, I believe, 2 days ago in the civil suit. And this complaint really lays out what they believe happened at 34 Fairview and also what happened during the following investigation. And it's insight into how this trial is going to go. I'm personally very curious to see how the defense is going to respond to this, especially given the fact that in the criminal case, we had a lot of evidence that didn't really pan out to benefit the prosecution. So I want to see how the defense is going to respond to this now that obviously Karen Reed is in a position where she can really highlight, hey, this evidence, for example, that John O'Keefe was hit by a car, the medical examiner even admits that he cannot or they cannot conclude that John O'Keefe was actually hit by a car. How's the defense going to respond to this? So I'm very excited about this. Now, before we get started, I actually want to add a little context to this. Alan Jackson came out and made a statement publicly about this complaint. And then the attorneys for the defense also came out and they responded and they have something to say. So we are going to go over the complaint, but first we're going to look at these tweets. Okay. And this is my first time going live, so forgive me as I try to do the layout here. Okay, here we go. I can't read that. This just released statement is from Alan Jackson and Karen Reed's civil team. This is what they said. Today's filing speaks for itself. It is a meticulously documented civil action grounded in evidence, law, and the Constitution. For more than 3 years, Karen Reed was dragged through a baseless criminal prosecution engineered by individuals who abused their authority, manipulated the investigative process, and trampled her rights. Our complaint lays out in stark detail the malicious prosecution, the conspiracy, the civil rights violations, and the intentional misconduct that these defendants visited upon an innocent woman. If these defendants want to answer for that under oath, we welcome it. What we will not do is legitimize a threat to file some imaginary defamation case, which, just side note, that was filed a couple days prior to this complaint, a defamation case against Karen Reed and Turtle Boy. That threat is nothing more than a desperate attempt by those defendants to distract the public from the very real legal jeopardy they now face. When people start waving around defamation claims to mask their own legal troubles, it tells you everything you need to know. They don't want sunlight, they want silence. Karen Reed spent years fighting for her freedom against a corrupted investigation. Now she's fighting for accountability. And unlike the criminal case, this time the defendants don't get to hide behind badges, back-channel favors, or manufactured narratives. They will have to answer in a court of law for every lie, every omission, every manipulated report, and every constitutional violation they committed. Karen Reed is not backing down. Our team is not backing down. Accountability is coming, and these defendants can threaten all the phantom lawsuits they want, but the truth doesn't flinch. Man, that isn't true Alan Jackson words, because the drama involved, the shade thrown, I don't even know if you can call it shade. I mean, it's so direct at this point. That is in true Alan Jackson words right there. And I mean, I think it perfectly highlights exactly what their intent is and what they are responding to. You know, Karen Reed, she went through 2 criminal trials. This was huge. And the investigation that went on, I think that this complaint perfectly lays out the timeline of events, which for me, as someone who's following this case, even I at times, and I watched the documentary on this, even at times I was a little confused. Okay, what exactly was happening when? What was going on here? Okay, this complaint lays it all out so well. It ties things together. It points out the pattern. It really is beautifully written. And that's why at the end of the day, I wanted to read the complaint with you guys rather than creating a separate video about it. It is so full of information that if I made a separate video about it, like, I would just read the complaint, you know? So, okay, so that's what Alan Jackson and the Karen Reed's civil team said. Let's see what the defense said. Okay. So this is from the attorneys for Higgins, Nicole Albert, Brian Albert, Jennifer McCabe, and Matthew McCabe. The allegations made by Karen Reed are entirely false, defamatory, and without merit. Our clients categorically deny each and every claim. This lawsuit is nothing more than a continuation of a baseless conspiracy narrative that has caused significant harm to the reputations and lives of innocent people. Our clients acted responsibly, fulfilling their civic duty as witnesses, and have participated appropriately in the legal process from the outset. Miss Reed's claims distort the facts, misrepresent the evidence, and target private citizens in an attempt to deflect blame. As reported yesterday, we will hold Miss Reed accountable for the harm she has inflicted and the conspiracy she and Aiden Kearney, also known as Turtle Boy, have manufactured. So a little shorter of a response there, but makes sense. What else are you really going to say? The attorney said exactly what they're supposed to say, right? Like, they're innocent, they didn't do this, this is baseless, all of that. It's as expected. Okay, let's move on to the complaint. And there might be a part 2 of this because, to be honest, I this could take a while. I have about an hour and a half to 2 hours here, might be longer, so we might have to do a part 2. But let's get started. Let's look into this, see what they're saying. And I just want to say hi to everyone who's live right now. Thank you guys for joining. You should talk in the chat. It's always fun kind of being able to see people talk in the chat and converse, see what's going on. But okay, let's get started. Okay, so here's the complaint. Now we have Karen Reed, and then we have all the defendants. Michael Proctor, are we surprised? Yuri Buchanan, Lieutenant Brian Tully, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. Now, my first response here was like, okay, all in their personal capacity. Where are the entities involved? Okay, well, this is why you pay attention to footnotes, right? Look at that right here. The Massachusetts State Police and Town of Canton will be added as defendants after presentment is made pursuant to GLC 258 Section 4. So that's just a Massachusetts law that kind of lays out the requirement of presentment for the Massachusetts State Police and Town of Canton, or specifically to public entities. So they will be added as defendants. I just wanted to point that out because my first response here was like, okay, why aren't the Massachusetts State Police involved or the Town of Canton? They will be added as defendants. I also want to point out here, plaintiff intends to move to consolidate this action with the related action estate of John O'Keefe et al., v. Rhett et al. Civil action, yada yada, for discovery and trial efficiencies. We already knew that was going to happen. That was talked about in court. So there's that as well. Okay, I'm just going to read it to you guys and give you my thoughts as we go. Okay. And I've obviously read this in advance, and this is very spicy. For 3.5 years, plaintiff Karen Reed was wrongly accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from the gross misconduct of the Massachusetts State Police, MSP, and those working in tandem with the MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe III. I'm just going to open up the chat real quick, so in case I have any issues with my audio or something, please tell me and I don't just keep talking and no one can hear me or something. It's a huge fear of mine. Now, after being acquitted of all charges related to Mr. O'Keefe's death, Miss Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who abjectly failed to ensure that justice was sought and served in the aftermath of January 29th, 2022. Karen Reed did not kill her then boyfriend, Mr. O'Keefe. Rather, in the early morning hours of January 29th, Mr. O'Keefe was killed in defendants Brian and Nicole Albert's home at 34 Fairview Road in Canton. That's going to be called House. In an altercation during a late night house party with other defendants, collectively the House defendants, which I just love that they're called the House defendants. After a night of heavy drinking, the House defendants responsible for Mr. O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders for help, among other actions, the House defendants conducted a Google search for information about Haas long to die in the cold. We all know about that one. Moved Mr. O'Keefe's body outside and placed him on the Alberts' front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle, that he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained on the Alberts' lawn until Karen Reed found him later in the morning. From the beginning, investigators from the MSP allowed the House defendants to direct the investigation away from themselves and towards Miss Reed. The House defendants were a well-connected and close social group with strong ties to law enforcement. The Alberts are a prominent family in Canton, and the investigation police officers knew them well. The lead investigator for MSP, Michael Proctor, grew up in Canton and resides there to this day. He has been and remains close personal friends with the Albert family. House defendant Brian Albert was a longtime Boston Police Department officer, and House defendant Brian Higgins was an agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF. Adhering to the unwritten rule of protecting their own, the blue line, Proctor and his MSP colleagues intentionally disregarded the obvious and compelling evidence tying the House defendants to Mr. O'Keefe's murder. Specifically, Mr. O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face and a deep gash to the back of his head, suggesting that he was punched and fell backwards, hitting his head on a rigid surface. He also had dog bite wounds and scratches on his right arm and forearm. Equally evident, Mr. O'Keefe did not have a single injury consistent with being struck by a vehicle. He did not have any broken bones or even a bruise on his legs, feet, arms, shoulders, torso, back, ribs, or anywhere below his neck that a medical examiner would otherwise expect to find on a person struck and killed by an impact from a 3-ton vehicle. Side note, so before I was a lawyer, I was a legal assistant for a personal injury law firm for 4 years. And so I did a lot of people getting hit by cars. Actually, also side note, I was once hit by a car, but that's a story for another time. And yeah, they do make a really good point here that there aren't any injuries consistent with being hit by a vehicle. The fact that he had no broken bones or any kind of major injuries below his waist is very odd. No bruises on his legs, feet, arms, shoulders, torso, back, all of that. I'll tell you this, I had a lot of those bruises when I was hit. So it's just, I mean, they're pointing to the obvious here. We all saw this in the criminal case. They didn't have much evidence in support of the idea that he was hit by a car. And so obviously, the plaintiff, the attorneys in this case are going to really hit that hard. And to erase any doubt, the Commonwealth's own medical examiner, the pathologist who conducted the autopsy for the Commonwealth, concluded that Mr. O'Keefe's body showed no signs of a vehicular strike. Yeah, there's a reason why this is going to be discussed so much. Despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures. Propelled by the House defendants' false statements, including that Mr. O'Keefe never went into the house, Proctor reported in text messages just hours into the investigation that the House defendants weren't going to get any shit for this because he's, Brian Alberts, a Boston cop, and that Proctor was determined to make the investigation cut and dry by bringing charges against the girl. Indeed, Proctor made his intentions clear in writing. Karen Reed had zero chance of skating. She's fucked. This pronouncement was a mere 16 hours after Mr. O'Keefe's body was discovered on Albert's lawn, and Proctor had not even walked into the house. Yeah, okay. Throughout this, Proctor gets mentioned so much. The text messages, everything about Proctor, he's hit so hard in this complaint. Yeah, and that makes complete sense. They're obviously going to target the weakest link, and I'm going to say Proctor here is the weakest link for sure. Okay. True to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash to the back of Mr. O'Keefe's head, or for fingerprints, or for DNA evidence. Proctor did not search the house despite the fact that Mr. O'Keefe was discovered without a winter coat, without the hat that several witnesses said he had been wearing that night, and without his left shoe. At Proctor's discretion, the house was never processed by a criminalist or even photographed. No member of the MSP, including Proctor, set foot inside 34 Fairview for nearly a week. The police did not examine or take evidence from the Alberts German Shepherd that was in the house on January 29th, a dog that had a history of attacking other dogs and people. Yeah, so this is huge because, again, it's laying out but in detail what was actually going on here. The fact that they didn't even go into the house for nearly a week, that's obviously a big blunder, and they're going to again emphasize that. Now, I understand, of course, you find a man, and I'm going to argue devil's advocate a lot here because that is my job as a lawyer, and I just think it's good to get a more well-rounded idea of this entire case and figure out why people may have been acting in certain ways. You find a man dead on your front lawn. Okay, you find your friend dead on your front lawn. It probably does look initially like he was walking to the house and something happened that resulted in his death. So of course they might not look in the house immediately because it would make sense that their first assumption would be that he walked into the house and then he got killed and then that he was dumped on the lawn, right? That being said, if they really looked at his injuries and the fact that he, like it said, wasn't wearing a winter coat and wasn't wearing a hat that several witnesses said that he'd been wearing, then they should have looked into the house much quicker than around a week, right? So again, I'm just trying to give slight understanding that there might have been a delay. I see how there could be a delay, but this much of a delay? I also do want to point out the German Shepherd thing. I'm not particularly surprised that they wouldn't look into the German Shepherd. Like, how would they initially assume that the German Shepherd would be involved in any regard? Obviously, it comes in after the fact. If they did a thorough search of everything, they should have been able to piece things together. But of course, the people piecing things together are the people involved in the situation. So that really complicates things. Conflict of interest here. Neither Proctor nor any of the MSP troopers conducted physical examinations of the House defendants for evidence of involvement in the altercation, such as marks on their hands, knuckles, or face, or bruises on their bodies. They did not seize or search the House defendants' phones. They conducted only perfunctory, unrecorded conversations with Proctor's friends and acquaintances without any attempt to corroborate their stories. They permitted would-be witnesses to communicate with each other and coordinate their stories before any formal interviews. They allowed critical evidence to be manipulated in some instances and outright destroyed in others. In short, by focusing the investigation solely on Miss Reed, as implicitly directed by the House defendants through the misrepresentation they made to police, Proctor and his colleagues disregarded and failed to obtain pertinent interviews and other critical evidence from the House defendants that cannot now be recovered or recreated. And that's exactly what the issue is that the people involved in this investigation were just too close to the accident. They were too involved in the accident to actually properly look into this. Putting everything aside, putting the accusation aside that, this is a cover-up, that they dragged O'Keefe's body out there, that Karen Reed, everything aside. You find a friend of yours dead on your front lawn, and then you just have everyone who is in the house also involved in the investigation. There are way too many crossovers here. And so this is also just highlighting, again, when you zoom out, how not to do an investigation, right? The fact that they didn't look at marks on the hands, knuckles, or face or bruises on the body, of course, because they're not going to look at John O'Keefe and be like, oh, maybe there was a fight in the house or whatever, and that might be why he's out here. That makes sense. They're not going to make that assumption immediately. But in this situation, because there's a conflict of interest or many conflicts of interest, they're never going to look into that. So this is just a total, I don't like swearing, cluster F. You know what I'm saying? Proctor also secretly communicated with the Alberts on his personal phone, deliberately back-channeling those communications to circumvent his state-issued device and used his sister as a conduit. So I want to point out here, deliberately back-channeling. I just talked about how this is a total mess of an investigation. If you zoom out, it's just how not to do an investigation, right? We have so many conflicts of interest. They're just not properly handling that. That is not intentional. But Karen Reed and her attorneys are arguing that this isn't negligence. These aren't mistakes. They are deliberate. They deliberately back-channeled the communications to purposefully circumvent his state-issued device. That is their point here, and it's important to note. These aren't just blunders, it's all intentional. For instance, on multiple occasions, Proctor disclosed critical and confidential information about the investigation to his sister, who passed that information to her close friend, Julie Albert, Brian Albert's sister-in-law. Julie Albert then passed that same information on to the rest of her family and the House defendants. Part of these communications included Julie Albert's promise to buy Proctor a thank you gift for handling this investigation in a manner that intentionally avoided implicating the House defendants and singularly focused on Miss Reed. Thank you gift? Really? Like, that's just so inappropriate. That's so inappropriate. No matter which way you slice it. Why are you giving thank you gifts to individuals in the investigation? Like, it just looks really bad. Proctor then went so far as to manufacture evidence to ensure that Miss Reed, not his friends and fellow law enforcement officers, was to blame for Mr. O'Keefe's death. This included planting evidence at the scene, on Mr. O'Keefe's clothes, and on Miss Reed's vehicle to support the false narrative that Miss Reed hit Mr. O'Keefe with her car, even though he knew Mr. O'Keefe's injuries were inconsistent with a motor vehicle strike and consistent with a physical altercation and dog attack. So the complaint's going to go further into this, exactly how they are alleging that Proctor planted evidence and all of that, but this is just essentially outlining their main arguments here. And I also want to point out here that there are a lot of holes here being filled from the perspective of the plaintiff by Karen Reed and her attorneys. Not everything here is fact. It is their narrative of what happened. Karen Reed did not go into that house. She didn't see Mr. O'Keefe get beat. She didn't see them drag Mr. O'Keefe onto the lawn. They're using circumstantial evidence, and then they're piecing it together to create the narrative of what they believe happened. And then they're going to argue that that is what happened, of course. And so I just want to point that out. It's a lot of circumstantial evidence and kind of putting that together. Now, just side note on circumstantial evidence. Circumstantial evidence is essentially like, okay, you don't see that it's raining outside, but you look outside and you see that the ground is wet. Okay, the inference from that would be that it rained, correct? So the circumstantial evidence is the fact that the ground is wet. And again, the inference that it's raining. Here we have inferences that Mr. O'Keefe got in a fight. He was attacked by a dog, that he ended up being dropped at the lawn, that this is a whole conspiracy. Far from conducting an objective investigation with integrity, Proctor personally sexualized and dehumanized Miss Reed throughout the investigation. Specifically, Proctor's private communications in his high school buddies, sister, and MSP colleagues that he believed would never be discovered exposed the corruption and bias at the core of MSP's entire investigation. Specifically, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor stated that Miss Reed is a whack job retarded, a nutbag, and a babe with no ass. I hate even having to read that. Proctor further ridiculed and derided Miss Reed for her serious medical condition, stating that her balloon knot leaked poo. In other private text messages to his MSP supervisors and colleagues, Proctor bragged that while conducting a search of Miss Reed's phone, he was looking for naked pictures of Miss Reed. Disappointed, he reported that there were no nudes so far. In an unfiltered utterance, Proctor revealed his true mindset. Hopefully she kills herself. Like, of course, this is all in this complaint, but like seeing it all together on a piece of paper and reading it and them creating this entire timeline is just like, oh my gosh. Indeed, Proctor's supervisors and the MSP knew about and condoned Proctor's unlawful conduct, and in some instances expressly encouraged this flagrant abuse of power. For example, on one occasion, Proctor's immediate supervisor, Yuri Buchanan, I always say his name wrong, Buchanan, responded with a thumbs up emoji to a text calling Miss Reed retarded. Proctor's supervisors and the MSP knew Proctor had a close relationship with the Alberts and that he made no secret of his bias against Miss Reed, demonstrating a clear prejudice against her from the outset. Relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing towards the House defendants, the Commonwealth secured 2 separate arrest warrants for Miss Reed and a knowingly baseless indictment against her, and then wrongfully prosecuted her for murder twice. As alleged below, these unlawful acts not only underlie plaintiff's meritless wrongful death claim against Miss Reed, but they also form the foundation for Miss Reed's claim against the defendants. These acts violate Miss Reed's state and federal constitutional rights, the Massachusetts Civil Rights Act, and well-established Massachusetts tort principles. This is the nerd in me, but I really love reading this because it is very well written. It is a beautiful, that's the nerd in me, beautiful. They are creating the narrative, the story, their argument, while incorporating a legal argument as well, and creating a timeline of all of the events. It really is. They must have worked very hard on this, and whoever wrote this should be proud of themselves. It's probably multiple people. They should be proud of themselves. On June 18th, 2025, after a 2-month trial, a jury rejected the Commonwealth's theory, in part because the overwhelming physical, scientific, and medical evidence established that Miss Reed's vehicle did not strike Mr. O'Keefe and that Mr. O'Keefe's injuries did not come from a vehicle strike. Although Miss Reed was ultimately and finally acquitted of all charges related to the death of Mr. O'Keefe, Proctor was fired, and nearly every MSP officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the O'Keefe family, not to the community at large, and certainly not to Miss Reed. Now, a lot of people have kind of pointed this out, that Karen Reed is the one who is working the hardest to actually figure out what happened to O'Keefe, right? They're pointing out that she is really working the hardest. And of course, if you're going to say that, then your belief is that Miss Reed is truly innocent, not just before the law, but truly did not accidentally or intentionally or anything like that kill John O'Keefe, right? If you're somebody who believes that Karen Reed did hit him with a car, then you're obviously going to say the opposite of that. In response, the Commonwealth has offered only empty platitudes instead of solutions. The head of MSP, Colonel Jeffrey Noble, stated, "The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as colonel, the state police has and will continue to improve in these regards." In an interview with the Boston Herald, Noble acknowledged the systemic nature of MSP's conduct in Miss Reed's case. Very systemic. Massachusetts is like on fire right now, essentially. I'm covering multiple cases in Massachusetts. It's like, holy cow. These hollow words do nothing to right the devastating wrongs that have been visited on Miss Reed. Colonel Noble's words confess a sickness deep in the marrow of the MSP, but offer no remedy, no medicine, no relief to someone so brutally victimized by it. On Wednesday, March 19th, 2025, following the public disclosure of Proctor's illegal and unethical conduct related to the Reed investigation, the MSP's trial board found Michael Proctor guilty of a Class A violation, which included that he was biased in his dealings with the homicide suspect and/or brought otherwise himself and the Massachusetts State Police into disrepute. Miss Reed's life was not merely turned upside down by the MSP's and the House defendants' misconduct, it was forever changed by the defendants' transgressions and wrongdoings. The year of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. At the same time, neither Mr. O'Keefe nor his family has received justice. Again, going back to this idea that Mr. O'Keefe and his family have not received justice because Karen Reed did not kill O'Keefe. Somebody else did, or other people did. So justice has not been found. His killer, or killers, still walk free. By asserting her claims against MSP, Proctor, his supervisor, the town of Canton, and the House defendants, Miss Reed seeks, at minimum, to confront and redress these wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own. And then it just lists the parties. Plaintiff Karen Reed. I kind of said all this in the beginning, so I'm not going to go over all of that. It's everyone as you'd expect. MSP and the town of Canton are going to come in later. Also, like I said, jurisdiction, venue, bunch of legal stuff. Okay. So now they're going to put forth the facts common to the counts. Now, again, this is their narrative, their story of what happened. They're taking circumstantial evidence, they're piecing it together with inferences, and they're writing their story of what happened. We know Karen Reed was not actually there for a lot of this, but given everything that came out in the two criminal trials and probably outside of that as well, they're able to piece something together and create an argument as to what happened to Mr. O'Keefe. Before his death, Mr. O'Keefe and Miss Reed were dating. On the evening of January 28th, 2022, Mr. O'Keefe and Miss Reed went out for the night. They first went to C.F. McCarthy's in Canton, where they had several drinks. They then went to the Waterfall Bar in Canton. There, they met up with a group of acquaintances, including Brian Albert, his wife, Nicole Albert, Brian's brother, Chris Albert, and his wife, Julie, Jennifer McCabe, Nicole's sister and Brian's sister-in-law, her husband, Matthew McCabe, and Brian Higgins. The group of acquaintances had several drinks and planned to continue the party back at the Alberts' home in Canton at 34 Fairview Road, the house. House defendant Jennifer McCabe told John O'Keefe that he should come to the house. The group had overlapping social relationships. Now, this is all just going to go over to how everyone's connected. At the time, Brian Albert was a Boston police officer, as was Mr. O'Keefe, though they did not know each other very well. Brian Albert and Brian Higgins were close friends. Higgins was an officer with the ATF. He also was permitted to keep an office at the Canton Police Department, CPD, CPD, alongside Brian Albert's brother, Canton Police Detective Kevin Albert. Kevin Albert had a professional and social relationship with Michael Proctor. Brian and I need water. Okay. Brian and Nicole Albert's son, Brian Albert Jr., and his friends were already at the house for Brian Jr.'s birthday. In addition, Colin Albert, Brian Albert's nephew, was present. So Colin Albert is not named as a defendant here. And some people were wondering if he was going to be. He's not been named. He's not a defendant in this case. Miss Reed and Mr. O'Keefe had never been to the house before January 29th of 2022. They arrived in front of the Alberts' home around 12:20 a.m. Miss Reed was reluctant to attend the party for several reasons, including that she was unsure whether they were at the correct location and whether they were even welcome to the late night party. Side note, also flirty texts going on between her and the ATF agent, right? That might be another reason why Miss Reed did not want to go into that house. Mr. O'Keefe got out of Miss Reed's SUV and indicated that he would check out the party and report back to her. Mr. O'Keefe walked toward the front door/garage door area of the house and entered one of the two doors. A period of time passed without any word from Mr. O'Keefe. Miss Reed, who was still hesitant to join, presumed that Mr. O'Keefe intended to stay, and therefore she left to go home without him. So again, connecting the dots here. We do not know definitively that Mr. O'Keefe walked through the front door, but of course, Miss Reed's team is going to say that is exactly what happened. At some point after entering the house/garage, Mr. O'Keefe was involved in a physical altercation either inside the house or garage. During that altercation, the Albert's German Shepherd attacked him, and Mr. O'Keefe sustained multiple dog bites and scratches on his right arm. He also suffered an incapacitating contracture wound, I've actually not heard that word before, on the back of his head. Mr. O'Keefe's head wound was caused by falling backward and striking a rigid surface. The Albert's garage contains such surfaces. By contrast, the head wound could not have been caused by a vehicle striking or falling backward onto a flat, cold lawn like the Alberts. Again, creating the narrative here. They are taking the circumstantial evidence that they have and they're saying, hey, look at this. It does not make sense that somebody with a huge gash on their head, that would happen from falling on the lawn. And I don't know how that would happen from getting hit by a car in the way that he was allegedly hit, right? So it must have been something else. Well, guess what? In the garage, we have many rigid surfaces. In a house, we have many rigid surfaces. What it actually looks like is that he fell backwards and he hit his head. Now, what made him fall backwards? Oh, he got punched in the face. This is how they're connecting all of it. Because of their knowledge of criminal investigations, the Alberts, the McCabes, and Higgins knew that calling for medical care to help save Mr. O'Keefe's life would trigger immediate and irreversible risk of their own criminal exposure. Therefore, at least the five of them agreed on a simple plan to exonerate themselves and implicate Miss Reed. They would tell anyone who inquired. Mr. O'Keefe never entered the house and hide evidence that he was there, including his body. Sometime during the night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view of that area of the lawn from potential passersby. At some point further in the night, they carried or dragged Mr. O'Keefe's body to that same area in the yard, close to where one or more of them later claimed Miss Reed dropped off Mr. O'Keefe earlier that night. The plan was devised to make it appear that Mr. O'Keefe had been struck by Miss Reed's vehicle and then died as a result of exposure to the cold. Mr. O'Keefe was either dead when the house defendants left him on the Albert's lawn, or he died shortly thereafter. After the physical altercation, Higgins left the house and drove to the Canton Police Department in the middle of the night. He later told investigators he had to do some administrative work, but then changed his story subsequently, stating that he drove to the station because they had to move cars in the parking lot due to the snowstorm. However, video from inside the station shows Higgins walking down the hallway and surreptitiously entering offices while wearing a hoodie to obscure his face. Surveillance video outside reveals Higgins transporting a large bag from one vehicle to another before driving away. That's like so suspicious. What was he doing? Why was he there? Right? And here's what's interesting, I think, in a lot of these kinds of cases and just stories in general is, and some of you guys may have known, I did work with Sergio Denaro. He's the deception detection expert, and he has pointed out when people are lying. Okay, you can tell when people are lying. You can tell when people are being suspicious, but you don't always know why they're lying, right? Let's say you ask somebody who needs an alibi, where were you the night of, Thursday the 13th of whatever, December, okay? And somebody says, I was at home. And they say something that makes you think that they're lying. And so that means that I was at home with my, grandpa who's injured or sick or whatever. And they say something that makes you think that they're lying. Okay. You can't immediately assume that because they're lying and that maybe they didn't have an alibi that night, that they then are the suspect to the murder, right? That they are the murderer. Maybe they're lying for another reason. Maybe that person has a gambling addiction and was actually at the casino and doesn't want you to know. Maybe that person was having an affair and they were off seeing their mistress or something. So sometimes people do things that are suspicious, and that thing that they do may not actually be connected to the case, but we don't always know that. And again, I'm not saying that what he didn't do or what he did is not connected to the case at all. This is super suspicious. When you stack everything up, it's just the case is really rough against the defendants in this case, for sure. But I do find it interesting that sometimes people could be doing something that is not allowed, and they might not want you to know that what they're doing is not allowed, but then they just get lumped in with, O'Keefe being killed. After leaving the police station, Higgins and Brian Albert continued to coordinate their stories by calling each other multiple times in the early morning hours, and ultimately spoke with each other on their cell phones at 2:22 a.m. Later, both Brian Albert and Higgins denied the existence of these phone calls, and then when confronted with their existence by a separate law enforcement agency, the FBI, a non-MSP and non-CPD law enforcement agency at a separate proceeding, they coordinated the same exact lie, falsely claiming the multiple calls and answers were just butt dials. However, 5 minutes after the Higgins-Albert call, Miss McCabe performed a Google search on her phone at 2:27 a.m. Haas long to die in cold, misspelling the first word, obviously. This is super interesting because there are just so many conversations about butt dials on this entire case, and everyone's like, oh, it's just a butt dial. It's like, butt dials went away when we moved to the iPhone because you now have a lock screen. Okay, you can say butt dial back when we had not even flip phones really, but when you had like the non-flip phones, I don't even know what those were called, but with the buttons, those butt dials make sense because you actually sit on it and you might hit the button and butt dial someone. But if you have a lock screen, the only potential butt dial you could do is 911 because I think you can call emergency services without going into the lock screen. But other than that, like you can't. It's just maybe in some cases if you left your phone open, obviously that's the case. But there are so many butt dials in this case. It's like, are you guys all like not locking your phone and just like constantly butt dialing people? And why are you only butt dialing people that were in the house? That's suspicious. Anyway, it's just ridiculous. Miss Reed searches for Mr. O'Keefe. So again, they're kind of breaking this up into the stages to help the reader follow along with what they say happened. Miss Reed began the search for Mr. O'Keefe on January 29th, just before 5 a.m., when she awoke and realized he had not returned home. She phoned House Defendant Jennifer McCabe, who already knew exactly what had happened to Mr. O'Keefe. That's an accusation. Miss McCabe insisted that Miss Reed drive to McCabe's house rather than driving to 34 Fairview Road, which Reed did. The two of them were then joined by Carrie Roberts, and the three of them left the McCabe residence. However, rather than go to 34 Fairview, oddly, Miss McCabe directed them to go back to Mr. O'Keefe's home, where Miss Reed had just come from. After, the three of them finally drove to 34 Fairview. The illogical, McCabe-directed route to 34 Fairview was intentional. It allowed the House defendants more time to finish creating the scene and hiding evidence before Mr. O'Keefe's body was discovered on the Alberts lawn and first responders arrived. Okay, I just want to go back to this. The plaintiff here, the Karen Reed's legal team, keeps going back to saying that this was intentional. It was not accidental. It was not negligence. It was intentional. And the reason why is because that's the entire case. They're arguing one of the counts is malicious prosecution. If you're going to argue malicious prosecution, you have to point out that it's not just that the prosecution failed in convicting the individual, because that happens very often. And if you could sue anyone for that, there would be a lot of lawsuits and they would be pretty frivolous. You have to point out that they were intentionally doing things, that they were planting evidence, that this was a plan. They were working together. They were trying to pin it on Reed or whoever in any situation, in any lawsuit. They're trying to pin it. It's intentional. So you're going to see the words like intentional, deliberate, all of this continue to show up throughout this complaint, because that goes back to what they are trying to, or one of their counts, the malicious prosecution. As they approached the house with Miss Roberts driving, Miss Reed saw Mr. O'Keefe almost immediately. She screamed for Miss Roberts to stop the vehicle and jumped from the moving car to run to Mr. O'Keefe. She began rendering aid, including CPR. As the House defendants had planned, Mr. O'Keefe's body was discovered in front of the Alberts' house near a flagpole and fire hydrant on the left side of the Alberts' property, as seen from the roadside. The Ford Edge, which had been parked in a position to obscure Mr. O'Keefe's body in the middle of the night, had been moved. I just find that interesting, that last part. I don't remember in the complaint them pointing out why exactly the Ford Edge was moved to obscure his body and then moved back in the middle of the night. I don't really see an incentive for them to do that. I do know that, there is debate over where the Ford Edge was and all of that. And so maybe they're just trying to, bring it into the story. But again, I don't really understand, like, if we're going to be in the mind of somebody who is trying to cover up Mr. O'Keefe's death and plant the body and all of that. I don't know why they would obscure his body first and then remove the Ford Edge. But if you have an idea, let me know. You can say something I'm not watching the chat right now because I would be so distracted and I would not be able to. Sometimes I peek a little bit. See, I looked right there, but I try not to look because I'd be so distracted. But comment and let me know what you think, what the motive could be there, because I'm very curious. Again, they're piecing together circumstantial evidence. Sometimes things are not going to come together perfectly, and it's going to leave us wondering, okay, why? That seems like maybe a hole in the argument here. What's going on? What is that point? But maybe I missed it in the complaint if it shows up later as to why, if they're going to argue why they moved that, we'll see. While Miss Roberts joined Miss Reed with administering CPR, Miss McCabe did not help or even approach Mr. O'Keefe. Rather, she sat in the cab of the vehicle, called 911, and reported there's a man passed out in the snow. I remember hearing that. It is very odd that she would just say a man rather than a friend. That being said, I could argue also that reporting the individual as they are, including their gender, may be important for first responders for some reason. And so maybe she just wanted to keep it simple and basic. But I did hear it, and I thought it was very odd that she would say man and not friend and really dissociate herself, right? Can't really figure out why she did that, but there's a couple reasons as to why. I also find this whole situation interesting because everyone was insanely drunk the night that this happened. And then they're all probably potentially still drunk or just really hungover. Like, this is such a mess. Despite knowing that her brother-in-law, Brian Albert, a police officer and first responder, was just feet away inside the house, Miss McCabe never went into the house or requested that Albert come down to help Mr. O'Keefe. That's suspicious. That's weird. Like, why wouldn't you? There was a potentially dead person on your front lawn. Why wouldn't you go into the house where you know there's a first responder and police officer and say, hey, wake up, we need help? Why would you call 911 and wait for them to come? That's odd, obviously, as they point out here. Rather, as Mr. O'Keefe lay dying in the snow, Miss McCabe stood and watched with no fear, urgency, or even concern for her family members residing mere feet away. Again, those are accusations. We have no evidence that she actually had no fear or urgency or anything like that. They're taking her actions and creating this narrative, but that's the whole point of this. Okay, now the investigation begins. The CPD were the first on the scene shortly after 6 a.m. At the time, there was no evidence that Mr. O'Keefe had been hit by a vehicle. In fact, the evidence suggested just the opposite. His body did not show signs of trauma commonly associated with being struck by a car. There were no bone fractures or trauma to his lower body or to his torso or any other part of his body, as investigators would expect from a vehicle strike. Rather, Mr. O'Keefe's injuries were consistent with being physically assaulted to the face and head and attacked by a dog. Again, if a first responder's there, I don't know how they're going to see that and be like, oh, he must have been attacked by a dog. But obviously, after the fact, we looked at this and one could argue that it does look like that happened. For good reason, the ranking CPD officer on the scene, Sergeant Michael Lank, opined on a telephone call captured on a dash cam that Mr. O'Keefe looked like he had been in a fight. That's big. Moreover, the initial search conducted by Canton police officers revealed that there was no vehicle debris on the lawn at 34 Fairview, let alone any debris at or near Mr. O'Keefe's body. Not a single piece of taillight material was discovered on the lawn that morning or in the roadway, notwithstanding multiple searches and the use of a leaf blower to remove snow. I was just checking the chat. Yeah, I do remember the leaf blower, the fact that nothing was there, and then suddenly things were there, and then they said, oh, it's because of the snow. Obviously, it's hard to find these things, and then we're going to put them in red Solo cups because that's not a problem. Like, tellingly, despite the commotion outside, including more than a dozen first responders, I know where this is going, 3 police cruisers, 2 ambulances, a ladder fire engine, all with their emergency lights flashing, and at least 2 civilian vehicles, plus Miss Reed's screams upon finding Mr. O'Keefe's body. No one from the Alberts' house, including police officer Brian Albert, ever went outside to see what was happening, let alone help. They wanted to avoid scrutiny from the police investigators. So we know that no one came out. No one offered help. These things allegedly did not wake anyone up, which is like crazy. But again, let's remember, I don't know. How does getting drunk and being hungover affect you? For me, if I drink and I'm hungover, I wake up crazy early the next day. I sleep like crap. But some people seriously go into like practically a coma. So maybe both the Alberts like drank so much they were just PTFO, like not there and didn't hear this. Or like they're saying they wanted to avoid scrutiny from the police investigators. I don't know. Sergeant Lank was a longtime friend of the Alberts and the first law enforcement officer to enter the house. He spoke to the Alberts and the McCabes. Pursuant to their plan, the Alberts and the McCabes told Sergeant Lank that Mr. O'Keefe had never entered the Alberts' house the night before. The Alberts and McCabes' statements were false. Mr. O'Keefe arrived at and entered the house or garage, where he was assaulted, attacked by the Alberts dog, and suffered a fatal injury to the back of his head. So yeah, now they're pointing to that injury to the back of the head. That is what killed him. And they're saying, again, he was assaulted. He went inside, was assaulted, attacked by the dog, everything. Despite Mr. O'Keefe's injuries being wholly inconsistent with the story the House defendants were now telling him, neither Sergeant Lank nor any other member of the CPD searched the house to determine whether the occupants or anyone else were involved in Mr. O'Keefe's death. Yeah, at this point, you have Sergeant Lank saying it looks like he was in a fight. You need to start looking around. You need to look in the house. This is a crime scene. nor did they request to search the occupants' cell phones, observe their bodies for evidence of a fight, or even secure the scene where Mr. O'Keefe's body was found. They failed to do so because of bias born of friendship and loyalty in favor of the Alberts and McCabes. So it seems essentially what they're doing here is each paragraph, they're listing out the details, and then they're coming to the conclusion in the last sentence, right? So, like this 47 here. This is everything that happened, inconsistent stories. They never looked into the house. They didn't search the occupants' cell phones. They didn't observe their bodies for evidence of fight, yada, yada. Then they failed to do so because of bias born of friendship and loyalty in favor of the Alberts and McCabes. That is their conclusion that they are coming to given the facts. After Sergeant Lank returned to the CPD 3 hours after the discovery of Mr. O'Keefe's body and more than 2 hours after being interviewed at the Alberts' home that morning, Miss McCabe called Sergeant Lank to report that she recalled additional information. As part of the plan to implicate Miss Reed and remove suspicion from the House defendants, she falsely told Sergeant Lank that Miss Reed told her twice that morning, "I hope I didn't hit him." More than a year later, at a separate proceeding, Miss McCabe changed her story on this topic yet again. In furtherance of the House defendants' plan, McCabe then falsely reported that Miss Reed outright confessed to hitting Mr. O'Keefe right after she first found him in the snow. Yeah, see, conflicting statements. That's going to get you. Also, again, these people are hungover beyond belief. I'm like, does anyone even really remember truly what happened? Like, Proctor leads MSP investigation despite conflicts. Michael Proctor was assigned as the case officer and had primary responsibility for the MSP investigation of Mr. O'Keefe's death. Sergeant Yuri Buchanan was Proctor's direct supervisor. Lieutenant Brian Tully was the supervisory officer at the Norfolk County State Police Detective Unit and thus supervised both Buchanan and Proctor. I need to pause every time. I just want to say Buchanan. That just like works in my brain. In their roles, Buchanan and Tully both knew at all times exactly the extent of Proctor's misconduct in investigating Mr. O'Keefe's death as described below. Also, chat, am I saying his name wrong? Like, let me know if I'm saying his name wrong. I don't think I am. I've heard it so many times, but I also read it one way in my head, and so then it just gets all twisted, and the wires are crossed the brain, and then I try and read it, and it's a whole thing. From the beginning, Proctor should never have been assigned as an investigating officer, let alone the lead investigator. Yeah, conflicts of interest here. Okay, this is, again, a lot of this is investigation 101. Like, they should, I don't know, in detective school, whatever school you go to be a detective, they need to, like, bring this case up and be like, this is what not to do. He grew up and resides in Canton, is a good friend of the Alberts, and had known the family for years. Proctor and Julie Albert, Brian Albert's sister-in-law, had each other's personal cell phone numbers. In fact, just days before Mr. O'Keefe's death, Proctor communicated with Julie Albert about babysitting Proctor's minor child. Proctor's sister, Courtney, was also a close friend of Julie. In fact, Proctor's own mother referred to the Alberts as the Proctor's second family. Like, inappropriate. The existence of these relationships was intentionally suppressed by Proctor and other members of the MSP, including Buchanan and Tully, in an effort to ensure that the House defendants were protected and that Miss Reed's right to a fair investigation and trial were undermined. So essentially, here he's arguing that they didn't want an objective or a third party or kind of outside entity looking into this because it was way too suspicious, and they need someone on the inside. They need the second family. They need the friend to be the one leading the investigation because these guys, they're guilty of conspiracy. They're guilty of cover-up. They're guilty of malicious prosecution. That is what this argument is. And so there is an incentive to keep Proctor on the team and to suppress these relationships because it benefits them. If you have an outside observer coming in, if you have an independent party, if you have someone who's objective, the attorneys here are saying, well, then they wouldn't be pointing at Miss Reed. They would be looking at the house, and they can't have that. Proctor, Buchanan, and Tully engage in a corrupt and biased investigation by not investigating inside the house and interviewing House defendants as friends rather than suspects. So this goes into exactly as I just said, that the entire investigation, it was corrupt, it was biased, they didn't look inside the house, the interviews were terrible, they were looking at the individuals as friends, not as potential suspects or as suspects. Miss Reed was essentially determined to be a suspect immediately. That's what they're arguing. Proctor, Buchanan, Tully, and the MSP never searched for DNA evidence inside the house, never looked for rigid surfaces that could have caused the gash on the back of Mr. O'Keefe's head, never inspected the house defendants' bodies for indication of bruises or cuts that resulted from an altercation, and did not search the house defendants' cell phones. This allowed potential evidence to be destroyed, disposed of, removed, or simply become unrecoverable. Proctor's, Buchanan's, and Tully's interviews of the House defendants were also outside of normal protocol. They were all interviewed either at their home, their family member's home, their lawyer's home, in the case of Brian Higgins, their lawyer's office, in the case of Brian Jr. and Caitlin Albert, their place of employment, or over the phone. These interviews were each untimely, unrecorded, and fundamentally designed to protect the House defendants. And the House defendants took full advantage of it. Specifically, Jennifer McCabe became the point person for the House defendants in providing their false narrative to investigators. She managed and communicated details about the House defendants' messaging and the investigation itself, including visiting Proctor's and other investigators' private residence, mapping out timelines to coordinate statements with other witnesses, leading group text message chains that were later partially deleted, and planning private meetings at all hours of the day and night. Indeed, these were never the acts of innocent witnesses seeking to help an investigation concerning the death of an alleged friend. Alleged. Because essentially they're pointing out John O'Keefe cannot be their friend if they killed him and then covered it all up. That's very purposely placed alleged right there. Rather, they were predicate acts of a conspiracy among a group of people with a shared goal of deflecting their criminal exposure onto someone else. So here he's really, and I say he because I'm thinking of Alan Jackson, but really it's a team of lawyers. It's Karen Reed's civil team. They are placing Jennifer McCabe as almost like, well, not almost, as the point person, as the individual who's pulling all the strings, bringing everything together, creating the communications, planning everything. Yeah, that's big. It's a big accusation. The remaining group texts that were not deleted or that were recovered later reveal some of their planning. For instance, on the evening of January 29th, Jennifer McCabe texted with her sister, Nicole Albert, that Carrie Roberts, who was present when Mr. O'Keefe's body was found, talked to the cops and kept it simple. Of course, there would be no reason to report back to the other defendants about Roberts keeping it simple unless what really happened was more complicated. Now, I do want to say, like I said, I'm going to be arguing both sides here. I'm a devil advocates person. I'm a devil's advocate, whatever. It's really hard talking for this long. So here's the thing. The assumption or the inference here that unless what really happened was more complicated, like there's no reason to say that you kept it simple unless it was more complicated. That's a bit of a stretch in my opinion. Talking to cops is scary. Okay, even if you're involved with the cops, like all of these individuals have close friends, this is still someone died. There was a person found dead outside of somebody's party. This is a big deal. No matter which way you cut it, whether you're on Karen Reed's side or not, it's a big freaking deal. And so keeping it simple, I mean, talk to the cops, kept it simple. Like, yeah, people are going to be scared to talk to the cops. They're scared about this entire situation. It makes sense that somebody should be told to keep it simple, or they kept it simple, something like that. So again, I don't know if this inference is really that strong here. But you know, Proctor, Buchanan, and the MSP never sought these communications. Rather, they were obtained by Karen Reed's defense attorney's repeated motions to compel access to data on Miss McCabe's iPhone. Later, in group text with Jennifer McCabe and Brian and Nicole Albert, Matthew McCabe suggested having Chris Albert publicize their crafted story to a reporter, saying, "Ask Chris to ask some questions. Tell them the guy never went in the house." As an endorsement of the plan, Brian Albert responded, "Exactly." Again, I mean, in another world, or in the defense's position here, this isn't damning. This isn't like, yeah, for sure they were conspiring. These text messages are proof that it's not like somebody straight up was like, lie and say that the guy never went in the house. Like, no one said that. Like, Brian Albert said exactly. Like, that's exactly what happened. So I'm just, again, devil's advocate, trying to point out here that some of these things, depending on how you read them, how you write it, all of that, you can make it look worse than it is or not as bad, right? And so, of course, in this situation, the complaint's going to make these text messages look like they're conspiring, but that doesn't necessarily mean that they are. Importantly, the text messages from the House defendants' phones that were ultimately recovered and that provide a window into their conspiracy and misconduct, as well as MSP's unlawful investigation, were not the product of CPD or MSP's investigative work. Rather, based on media reports raising serious questions about MSP's investigation and the House defendants' role in Mr. O'Keefe's death, another separate law enforcement agency, the FBI, began its own subsequent investigation. That investigation, and not MSP's, resulted in obtaining the House defendants' phones, taking statements from the House defendants, and conducting a separate proceeding, all of which MSP refused to do itself. Indeed, the evidence procured by the separate law enforcement agency's investigation demonstrates the House defendants' conspiracy and unlawful conduct, as well as MSP's bias and corruption. Proctor and Buchanan initially interviewed the McCabes and Brian Albert on January 29th at the McCabes' home at 12 Country Lane in Canton, at which time they again falsely stated that Mr. O'Keefe never entered the Alberts' home. Buchanan and Proctor did not interview Nicole Albert and Brian Higgins until February 3rd, 2022, and did not interview Chris and Julie Albert until February 10th, nearly 2 weeks after Mr. O'Keefe's death and more than a week after Miss Reed was arrested and charged. Before both interviews, the McCabes and Alberts continued to coordinate their stories as evidenced in group text. I really want to see, I'm excited for what else is going to be brought forward, because I would like to see more evidence that they're coordinating their stories in group text and all of that. I want that laid out. I want to read all of it. I want to review all of it. Proctor, Buchanan, and Tully likewise failed to conduct a meaningful investigation into Higgins' involvement. When Proctor and Buchanan interviewed Higgins on February 3rd, Higgins presented the troopers with a select set of self-curated texts between himself and Miss Reed. They learned that Higgins and Miss Reed had been exchanging flirtatious texts, and that Higgins reported at least one instance in which Miss Reed and Higgins had kissed while at Mr. O'Keefe's house mere weeks before his death. Which, I mean, yeah, we have a love triangle now. Rather than pursuing Higgins as a possible suspect, Proctor, Buchanan, and Tully neglected to investigate the matter further. They never interviewed Higgins again, even after surveillance video revealed Higgins was suspiciously hiding his face in the halls and the parking lot of CPD at 1:30 a.m. on January 29th. The video contradicts Higgins' statements about his actions that night. However, not only did Proctor, Buchanan, Tully, and MSP not investigate what Higgins was doing or what was in the bag, but they went so far as to hide this video from Karen Reed and her criminal defense attorneys for years. Reed's defense did not receive these videos until after Reed stood trial for the first time. Yeah, I see why they're emphasizing the word after. Karen Reed stood trial and was accused of killing her boyfriend. And they didn't get this evidence, they didn't get these videos until after, essentially highlighting how dangerous of a situation that Reed was in. That she got out with a hung jury. I mean, she could have been convicted, and this evidence was not brought forth. That's a huge problem. And even after the separate law enforcement agency's investigation revealed late-night phone calls between Brian Albert and Brian Higgins, MSP failed to pursue either witness further to seek a full forensic extraction of Higgins' phone or even a simple call log from his cellular provider. When it was revealed that Miss Reed's defense team requested the preservation of Brian Albert's and this is crazy, and Higgins' phones in order to forensically image them, this request was allowed by the court. Both men got rid of their phones within days of one another. Higgins went so far as to drive to a military base on Cape Cod, remove the SIM card from the phone, cut the SIM card with scissors he brought with him, and destroy and dispose of the phone and card separately in 2 dumpsters, and then drive back home. Their destruction of their phones eliminated potentially incriminating communications between them and was a direct result of Proctor's, Buchanan's, and Tully's intentional refusal to collect important investigative evidence that would be exculpatory to Miss Reed. Even after learning about the destruction of both witnesses' cell phones, MSP investigators had other avenues they could have used to pursue evidence, such as cellular toll records or simply interviewing Brian Higgins and Brian Albert to inquire about the nature of the late night communications. They intentionally ignored these avenues as well. Intentionally, again, intentional, right? Malicious prosecution. Not only did Proctor fail to probe his friend's stories, he coordinated with them through his sister. Proctor spoke to Courtney multiple times a day and knew she was in close contact with and providing information to Julie Albert. Julie and Courtney called each other many times between February 1st and 2nd, and at least 67 times between February 1st and September 6th, 2022. For example, as he prepared to question Chris and Julie Albert on February 10th, Proctor told his sister Courtney that the interview was not a big deal. Courtney told Proctor that Julie Albert had been nervous and wanted to give him a thank you gift after the interview. To avoid scrutiny, Proctor instructed Courtney to tell Julie to give the gift to his wife, Elizabeth Proctor. I think, like, setting all of this aside, the very fact that Proctor was like, yeah, I'm still going to accept this gift, just give it to my wife. Proctor should have just been like, don't give me the gift. It's inappropriate. Like, you should not be giving me a gift during this investigation. But really, do we expect less from Proctor? Do we expect anything else from Proctor? That's what I mean. But I just like, it's all these side things. I'm just like, okay. Man, my throat. Okay, we're gonna go for another probably half an hour. I want to get 50% of the way through this. We're almost there. Okay, I think this is like, it's a 46-page document. So what's half of 46? 23, right? I'm really bad at math. 23. When we get to the 23rd page, I might end it, might go till 12:30. We'll see. Okay. Proctor shared investigatory details with Courtney before they were public. In the same instance referenced above, when his sister informed him that Julie Albert had been so nervous before the interview, instead of investigating further, he shrugged it off, laughed, and asked why. But Proctor knew exactly why Julie Albert was nervous. He sought to reassure her by telling Courtney that it was fine, just a quick combo. And then after the interview, Proctor spoke to Julie on his personal cell phone in an unreported conversation. Proctor never treated the Alberts as witnesses in a murder investigation. He treated them like the family friends that they were. Now, again, you can see the goal here of Karen Reed's civil team, right? The question of he shrugged it off, laughed, and asked why, but Proctor knew exactly why Julie Albert was nervous. Okay, if you were the attorney for the defense in this situation, you would then say, he asked why because there was no reason to be nervous. She's not involved. She didn't do anything. Nothing happened. Karen Reed hit John O'Keefe with his car. That's what the defense would say to that text, right? So again, the way you frame it and the way you come at it can make something as simple as a question of why mean something completely different. It means completely two different things in this situation. So I just want to point that out. Just me nerding out. I find this stuff interesting. At one point leading up At one point leading up to some of the interviews, Miss McCabe asked Nicole Albert if she had heard anything more about the investigation. Confident she would learn more from Julie Albert, again through Courtney, Nicole Albert responded, "We'll get more info tomorrow. Don't want to text about it." Tomorrow. House defendants did not want to text about their activities and communications because they tried to hide and or lie about them. For instance, it was discovered in the second criminal trial that Miss McCabe had lied in her sworn testimony in the first trial about not visiting 34 Fairview with Carrie Roberts on January 30th on their way to Michael Lank's house. However, while they did not text about this meeting, McCabe's cell phone location data obtained later by Reed's defense reveals that she did, in fact, visit 34 Fairview just one day after O'Keefe's death and lied about it. The McCabes, Alberts, and Higgins all told the same false story to investigators in their interviews, and Proctor, Buchanan, and Tully accepted their coordinated statements without making efforts to corroborate their stories. Rather than investigate their friends and brethren, Proctor, Buchanan, Tully, and MSP target Karen Reed. I wonder if the term brethren was used purposefully, probably because it was like trying to show the brethren the connection with the police officers, the thin blue line, the, helping out your own kind of thing. Instead of taking the routine, objective, and necessary steps of investigating the McCabes, Higgins, and the Alberts, Proctor, Buchanan, and Tully focused exclusively on Miss Reed as a suspect from the start of the investigation, despite substantial evidence exonerating her and implicating others, just as the House defendants intended. Proctor seized Miss Reed's cell phone and her SUV within 30 minutes of interviewing her on January 29th. He arrested her 72 hours later, before reviewing any surveillance from the bars or ring camera footage, before interviewing exculpatory witnesses, and before the medical examiner's official conclusion that the manner of death could not be determined, and that there were no injuries to Mr. O'Keefe's body consistent with a vehicle strike. Yeah, that looks really bad. Seizing Miss Reed's cell phone and her SUV within 30 minutes of interviewing her? I mean, when you compare this and how Karen Reed was treated to how the other individuals, the House defendants, were treated, what happened with their interviews, when those interviews occurred, it is a stark difference. It is apparent that, if nothing less, the investigator, or the Proctor, the investigators, the people involved in this, decided that Miss Reed did this before even seeing any of the evidence, which is exactly what this paragraph is saying, right? Before the medical examiner's official conclusion even came out, before they interviewed exculpatory witnesses, before even reviewing surveillance from the bars or ring camera footage, they decided Miss Reed was guilty before anything else. And that's what this is all about. Much to Proctor's surprise, through the separate law enforcement agency's investigation, his contemporaneous text messages were discovered. Among them, Proctor texted with his high school friends on the evening of January 29th, the day he began his investigation. He told them that the MSP had already determined the Alberts were not going to receive any scrutiny about Mr. O'Keefe's death, even though the MSP had not at this point visited the crime scene or been inside the Alberts' home, and had performed only a cursory interview of the McCabes and Brian Albert. Proctor told his friends that Mr. O'Keefe had been hit by a car and had not been in a fight, despite the fact that Mr. O'Keefe had suffered no injuries consistent with a vehicle strike. But he did have injuries consistent with a fight and a dog attack. Proctor rejected a friend's belief that Brian Albert, the homeowner of the property where Mr. O'Keefe's body was found, would receive some shit, instead agreeing with another friend's assumption that you guys, the MSP, are out to make it cut and dry since it involves cops. Proctor revealed that he had already decided he was going to put serious charges on Miss Reed and that she was fucked, and that there was zero chance she skates. From the outset, Proctor had determined to pin it on the girl. Okay, that's the malicious prosecution aspect of it, pinning it on someone. Intentional. All of these text messages support that. His intent when going after Miss Reed. They're arguing it was not actually to solve this situation. It was not actually to find justice. It's not actually to, figure out what happened to John O'Keefe. In reality, it was just to pin it on the girl. She's fucked. She has zero chances. That's what they're arguing here. Proctor's supervisors were aware of his bias and conflicted relationships in this investigation. They didn't have to guess. Proctor told them. He told them he knew the Alberts. Text messages from Proctor to Buchanan and other MSP troopers show Proctor had decided to focus suspicion on Miss Reed to the exclusion of everyone else. He told the troopers that Miss Reed was retarded and that he was searching her phone for nudes of her. Yeah. In the text chain, Sergeant Buchanan liked Proctor's text describing Miss Reed as retarded. Buchanan received Proctor's text and never reprimanded Proctor or addressed his improper bias and conduct. Yeah, that's really bad. Because he was determined to put serious charges on Miss Reed, Proctor ignored the fact that the Commonwealth's medical examiner could not conclude that Mr. O'Keefe's death was a homicide, determining instead that the manner of death could not be determined. The medical examiner also refused to conclude that Mr. O'Keefe died as a result of being struck by a vehicle, and later testified at trial that his injuries were not consistent with a car strike. I'm really wondering how the defense is going to get around this one. That's huge. Proctor later admitted that, in his entire career, he had never seen a homicide investigation where the medical examiner could not determine the manner of death, but he remained undeterred in his quest to charge Miss Reed. As he later admitted, the medical examiner's refusal to rule the death a homicide did not matter to him, because either way, Miss Reed was going to be charged. That's some tunnel vision. It's frustrating reading this because I've been looking at other cases in Massachusetts. I mean, Sandra Birchmore, right? And Ellen Greenberg too. That was in Pennsylvania. But I'm talking about these other cases where law enforcement, where the detectives, the investigators have tunnel vision. They decide what happened before looking at any other evidence, and they refuse to look anywhere else. They refuse to change their mind. And I mean, if we're going to really zoom out here, this is like lots of people's problems. People don't like to change their mind. They don't like to be told they're wrong. They don't like to be presented new evidence. It is not in our nature to do that. And it is frustrating to watch the mishandling of these investigations and the injustice that occurs as a result of it. It's just frustrating. Proctor and Buchanan plant certain evidence and make false statements in court and other legal documents to frame Karen Reed. Proctor made this investigation cut and dry by manufacturing a case against Miss Reed. A crucial first step was to ensure that the crime scene and evidence was not secured. This was in violation of MSP policy and well-established best practices for critical incident investigations, and also just freaking common sense. Specifically, the MSP crime laboratory requires proper processing of evidence at major crime scenes, including crime scene photography and evidence processing, and recovery of latent fingerprint, footwear, and tire track evidence. Neither the MSP troopers involved in the investigation nor the CPD police officers on the scene secured the Alberts home or the area where Mr. O'Keefe's body was found. The MSP did not take any photographs of the house, including any part of the yard where O'Keefe's body was found, until February 1st, more than 3 full days later. No photographs were ever taken of the inside of or garage of 34 Fairview. This intentional departure from established protocols permitted Proctor and Buchanan to generate false incriminating evidence against Miss Reed and give the House defendants time to destroy the actual evidence. By approximately 2:30 p.m. on January 29th, before he had even met or interviewed Miss Reed or seen her Lexus SUV, Proctor had already ordered seizure of the vehicle at her parents' home in Dighton. By 4:17 p.m., the vehicle was in MSP's physical possession. The vehicle was then towed to the CPD Sallyport, the infamous Sallyport, even though the MSP has at least 2 closer barracks and Massachusetts was in the middle of a historic nor'easter. That must be, I'm not from the Northeast. I'm guessing that has to do with the blizzard. Proctor knew he had more leeway to manipulate evidence regarding the SUV at CPD than at MSP's facilities, and he knew he needed to have that evidence in close proximity to the crime scene at 34 Fairview Road. So I think this is really interesting too. I had not heard of this prior. The fact that the vehicle could have been towed to at least 2 closer barracks, and the fact that there was a blizzard going on here, and they towed or a nor'easter, and they towed the car, the SUV, to a place that was farther away. That is very odd. Before the vehicle arrived at the garage, Miss Reed's Lexus's taillight had a minor crack but was intact. The crack occurred when Miss Reed backed into Mr. O'Keefe's car at 5 a.m. that morning as she was leaving to search for him. That incident was captured on video, and we all saw that video. I mean, yeah. Buchanan and Proctor followed the vehicle from Dighton and arrived at CPD at 5:35 p.m., just moments after the tow truck with the Lexus. At some point after the vehicle arrived at the Sally Port, the right rear taillight was almost entirely destroyed. Video taken from different angles in the Sally Port shows Buchanan, Proctor, Canton Police Chief Ken Berkowitz, and other individuals near the taillight. But notably, no video captures the taillight's appearance at the precise time it arrived at the Sally Port, so you can't compare. The available surveillance video from the Sally Port, as well as a CPD access card swipe log obtained by a separate law enforcement agency, reveal seemingly unfettered access to the Sally Port by a myriad of individuals throughout the evening of January 29th, including just before and just after 5:30 p.m. It's myriad. Yeah, I'm seeing in the chat mention about the Birchmore case. Yeah, the investigations into the Birchmore case, the investigation was just it's painful to read about. I lost my spot. Okay. One or more of them destroyed the taillight, secretly took pieces of it into their possession, and then planted some of them in various places at 34 Fairview and on Mr. O'Keefe's clothes. This is why this complaint is so interesting to me. I'm fascinated because these are things that were hinted at in the criminal case but could not necessarily be seen. And that's why I said at the beginning of this video that Karen Reed and her team are pulling no punches. They are in the offense now. They are writing the narrative, and this is what they're writing. Knowing that there were video cameras both inside and outside the Sally Port, Proctor and Buchanan worked together to obscure their role in manipulating the right rear taillight and then ultimately to present false evidence at the first criminal trial. Specifically, Proctor directed Buchanan to secure video footage from surveillance cameras located both inside and outside the Sally Port garage, which he did. These videos were manipulated in two significant ways. Again, manipulated. That is an intentional word right there. They're not saying it was an accident. They manipulated it. I'm getting distracted by the chat. First, a critical 42-minute portion was deleted from the footage from the Sally Port front wall camera. The portion from 5:08:02 p.m. to 5:50:50 p.m., which included the exact time Miss Reed's Lexus arrived in the garage. How convenient. We have discrepancy over her back tail light, and we can't see how it looked when it arrived because when it arrived, the footage is no longer in existence. And it points out that they arrived right around the time her car arrived too. So they were there with that car during that time period, and we don't have any footage. Oh. This footage would have shown that the taillight was intact. Second, footage from the Sally Port back wall camera was inverted, which made the right side of the Miss Reed's vehicle appear to be the left side and vice versa. Another camera, main driveway side exterior, captured the back end of the Lexus as it arrived at CPD, but was too grainy to decipher the condition of the passenger taillight. The videos from inside and outside the Sally Port and Proctor's request for Buchanan to obtain it was intentionally hidden from Karen Reed and her defense attorneys for more than 2 years to avoid scrutiny. The video was then sprung on them immediately before and during the first criminal trial. One driveway camera's footage was not revealed to the defense until just prior to the start of the second trial. Again, emphasizing the fact that things are happening after the first trial or at the beginning of the second trial. It's further highlighting how scary of a situation this really was for Karen Reed, barring everything else, just only looking at the fact that she was a defendant, that things were not coming out until she got the second trial, or the second trial occurred to her. That's terrifying. If she was convicted in the first trial, the stuff may not have ever come out, probably would never have come out. That is terrifying. In fact, Buchanan presented one part of the video during his direct testimony under questioning by the Assistant District Attorney Adam Lally. Buchanan narrated the video to the jury, correctly identifying that Proctor was at the rear of the vehicle, but claimed that he never approached the right rear taillight area of the vehicle. That testimony, however, was entirely false, as he well knew. The video that Buchanan authenticated as fair and accurate was actually neither fair nor accurate because it had been inverted. Proctor was actually behind the right taillight, for a significant period of time. But because it was inverted, it appeared in the video that he was behind the left taillight. They hoped this would allow Buchanan to lie about this issue at trial without detection. With this video and Buchanan's false testimony, the MSP Proctor and Buchanan attempted to mislead the jury in order to conceal the tampering with and planting of taillight material. So this is how they're tying everything together, right? That they are tampering with the taillight material, that they're planting it on the lawn, on John O'Keefe's clothes, all of that. The fact that when they initially looked at John O'Keefe's clothes and they initially looked in the area around at the lawn, they didn't find anything. But then later they did find something. Why is that? Well, according to Reed's lawyers, this is why. They're filling in the gaps. They're saying, look at the story. This is how it happened. Proctor and Buchanan also took taillight pieces from the Sally Port, brought them back to 34 Fairview to plant them in the location where Mr. O'Keefe's body was found, and then falsified various documents in an attempt to hide their conduct. Now, I just want to point out, these are huge allegations. Falsifying various documents, planting evidence, these are huge accusations. In warrant applications to the Stoughton District Court and Norfolk Superior Court for searches of Google's electronic records, ring videos, Miss Reed's phone, Miss Reed's vehicle, cell tower records, and other sources of information, Proctor swore he seized Miss Reed's vehicle from her parents' home at 5:30 p.m. on January 29, 2022, and had the vehicle towed to the CPD. Reports shared by the Dighton Police Department in 2023 reveal that the Lexus was towed from Dighton at 4:17 p.m. Proctor's assertion that he seized it at 5:30 p.m. was intentionally false to hide the fact that the car was in police custody for 73 minutes longer than indicated in his sworn affidavits, and essentially alluding here to what was going on those 73 minutes. It's unaccounted for. What happened? Proctor maintained that Sorry, I'm reading the chat. Proctor maintained that false narrative because it would hide the exact time frame when he had the opportunity to remove pieces of the taillight from Miss Reed's vehicle and bring them back to the house so that he could later claim the pieces had been there since approximately 12:30 a.m. on January 29th. However, unbeknownst to him, driveway video from the Reed residence in Dighton and a report written by the Dighton Police Report revealed Proctor's lie and revealed the true and accurate time the Lexus SUV came into MSP's possession. Proctor also deposited the SUV taillight pieces that he and others removed from the vehicle in the Sally Port on Mr. O'Keefe's clothes. Proctor retrieved Mr. O'Keefe's clothes from the floor of the hospital where he was pronounced deceased. Instead of securing the clothes in a sealed container or bag, as protocol requires, Proctor and Buchanan drove them around in his car all day and then placed them in the Norfolk County District Attorney's office for at least 6 days, where they were accessible to Proctor, Buchanan, and any other MSP troopers. That's like painful to read. I don't know what my deal is, but one of my biggest pet peeves when reading these kinds of investigations is when they mess up the chain of custody. It's just like when you create a situation where something is unaccounted for or it's just sitting around for 6 days and it's not in a sealed container and people can just access it easily, that really annoys me. It's a pet peeve of mine. It is. Probably because I see it a lot. I see it so much at this point. It's just like, you guys, come on. Proctor and Buchanan failed to create a log to document the chain of custody of the clothing. Therefore, and by design, there is no record of when, how many times, and under what circumstances Proctor and Buchanan touched, manipulated, handled, or otherwise tampered with that clothing. The MSP Evidence Submission Handbook dictates that chain of custody begins at the time of collection and that the collector seal evidence packages as soon as possible after collection to ensure integrity of evidence items and limit loss of transient evidence. Here, in violation of MSP's stated policies, the chain of custody for all of John O'Keefe's clothing, as well as dozens of pieces of taillight material, does not begin until March 14, 2022, nearly 2 months after it was collected, when Proctor finally submitted it to the MSP crime lab. At some point before providing those clothes to the crime lab, Proctor and/or Buchanan placed pieces of the SUV taillight on them where they were then identified by the crime lab in 2023. Proctor also planted pieces of glass on the bumper of Miss Reed's SUV while it was in his possession at the CPD Sallyport garage, which he then claimed to have recovered later on February 1st. Proctor planted this evidence to make it look like these shards originated from a cocktail glass that Mr. O'Keefe was holding when he exited the Waterfall bar. Okay, yes, I remember this because it's like, okay, you're telling me that this SUV was towed during a nor'easter, and then suddenly in the Sallyport garage there are shards of a cocktail glass just sitting on the bumper. It didn't fall off. Like that's a stretch. Okay. Evidently, Proctor did not plan on Karen Reed's defense attorneys insisting on forensic testing on the glass shards, which showed that they did not match the cocktail glass in Mr. O'Keefe's possession. In fact, the 5 glass pieces originated from multiple different sources. One shard of glass on the bumper did match another piece of glass that had been in Proctor's possession during the investigation. The only way for the glass to have ended up on the SUV bumper is that Proctor planted it there in an attempt to connect the vehicle to the death of Mr. O'Keefe. Yeah. Okay. I think I'm going to end this here because we are over halfway through. We are an hour and a half into this, and sorry, response to the chat. Okay. So I'm going to end it now because we're an hour and a half in. We are over 50% of our way through this complaint, and we're going to do this another day, probably tomorrow. And we can cover all of this. I want you guys to write some questions in the comments, and maybe I'll answer them in the next live because I think that, oh, I'm sorry. Because I think I totally lost my train of thought. This is why I can't read the chat. Okay. I think you guys should write in the comments any questions or comments that you might want me to answer or talk about in the next live stream, which I'll be doing probably tomorrow. I'll read the rest of this and then I'll answer some of those questions. I'll discuss more of what you guys are thinking, what you're considering, all of that. But for now, I do want to close this out so that it doesn't run on for like 3 hours, and my throat honestly is killing me. So I'm going to go drink some hot water with lemon and honey or something. Yeah, I agree. So somebody just said, Matt Mello 1070 said, they said the clothes had to dry out. Still, that's not an excuse for not creating an evidence log. You're correct. It is not an excuse for that. But of course, there's always going to be, people are going to have reasons for everything they do. Okay, anyways, I just want to thank all you guys for watching this. This was my first live, and I was a little nervous, but I had a lot of fun. I really enjoyed it. I want to keep doing this. And yeah, I just really hope you guys check in. I will do this again tomorrow. I'll just come 11 a.m. Central Standard Time tomorrow. That would be the 20th. We will finish the rest of this complaint and we'll just chat a little bit about kind of what was mentioned in the complaint and all of that. But until next time, I hope you guys all stay safe and stay curious. And I'm excited to see you tomorrow. See ya.